So, good morning. Hamza, how have you been? How are you? That's a nice suit you have on.
Thank you, Emma.
We also saw that you have had a few... You also had something to say about the Kpandai seat, so we'll get in there. So there are a few matters arising this morning. OSP controversy, we'll be asking the question whether the repeal is an orphan. I know categorically your stand and your position about the office of the special prosecutor, the prosecutor himself, but we'll get into it. And as well, we shall talk about Kpandai, the seat. Now that the NDC member of parliament is in court, hoping that their EC chair would be cited for contempt, the EC has actually also announced a date for that rerun. The NPP parliamentary, right? So they are in court, but now the EC they have also mentioned the date that the rerun is going to be happening. When we have time, we'll get into lithium mining deal agreements that has been withdrawn as well. We'll also talk about the Ghana-Israeli situation that has hit us as a country.
An important matter.
It is an important
Very important issue.
Okay, so let's start with the OSP. I'll start with you, Kamal.
Well, once again, I think we have already sent salutations to our viewers. And it's only the late Kamal who I may have to say good morning to. Hamza, how are you?
I'm well.
Anyway, MFA, you see, we are not in a banana republic. Ghana isn't a banana republic. The days of kangaroo courts, far gone. The days people decide to take law into their hands and do whatever they wish because we were under autocratic rule, far gone. What is supposed to be today is the manifestation of the rule of law. And I'm happy we have a lawyer sitting in our midst here. He may understand it and appreciate it better than us. You see, the rule of law is supposed to be the fundamental pillar of our growth as a democracy. This Kpandai matter is not as if we haven't traveled that journey before as a country. Zakaria Nimakan case, internally initiated. And how did it end? The Isaac Amu case of Owusu West Wagon are precedents we can cite. Okay? These two cases are there. And of course,
You're talking about the OSP, or you have gone to Kpandai?
Sorry, I thought you said we should deal with Kpandai.
No, let's start with the OSP.
Okay, that's fine. I wanted to. Why you be confused?
Because
but it's okay. It's still a matter. It's still a matter we are going to talk about anyway. Well, it's still okay. You can't be confused. You can never be confused. Why? It's a matter we have to deal with. And it's an important issue.
Yeah, we'll definitely get into that.
Who knows if I'm setting the agenda?
Maybe.
You set
anyway, no, I'm not saying so. But I'm just asking a rhetorical question. Anyway,
so the OSP matters arising there.
Very well. On the OSP matter.
Yes.
Even though we'll come back to this Kpandai issue.
You must be very passionate about it.
I'm so passionate about it because the lawlessness is just too much. That's why I'm really worried about it. There's so much lawlessness in our society.
Let's start with it.
And that's why Parliament so much.
Let's start with it.
We should start with it.
Yeah, you have just...
So like I was saying, if we have laws established for ourselves that we need to follow, we should not, just because it suits us, just because of our parochial interests, decide to put the law aside and do what we want to call politics. What the NDC is doing is sickening. My brother is here. Article 112 of the Constitution is clear as to when the clerk of parliament or parliament is supposed to declare a seat vacant. Article 99 of the Constitution is clear as to how and actually a seat is going to be declared vacant by the judiciary. It's a judicial decision and not an administrative decision. He knows it. Now, if there's a problem with a particular election, then you invoke the powers of Article 99 of the Constitution and go to court. What you are supposed to do is that there is a travel you are supposed to embark on. Which travel is that the first case of instant is listened, trial court will look at it. As and when there's an appeal pending, it means that the judicial process hasn't ended. That is why I cited the Zakaria and then the Isaac Amu case. Until the matter is determined at the appeals court and finalized, where you then say that the case has now been finalized, and therefore Parliament can now invoke Article 1125 to then say that you are going to declare the seat vacant and write to the EC. This is not what we are saying here at all. And unless a disingenuous lawyer who wants to come and sit down and say this process is not supposed to be so. Why? In the instant case, Kpandai matter ended in Tamale. The person who you have ruled against says that, look, on the face of it, we see an error in judgment. Therefore, I am appealing, which the Constitution mandates the person to do, and have appealed. Then you then sit in Parliament and write to EC and tell EC that, look, the seat is vacant, go and do election. Really? When it's not determined? My God, what kind of country are we running?
Okay, let's
get serious. And I'm worried about it. And I think that it could be, look, it can be someone today, and you will laugh over it.
Let's do some learning today. Let's get into, and this is important because my Thursday panelists are quite a powerhouse, and there have been concerns that beyond the conversation, they want to do some learning, especially on Thursday.
Great.
And so, Hamza, and he's raised a very important point. I've also seen you make a few comments on this Kpandai issue. Is this you? Have you made comments about the Kpandai? Have you blasted the Clerk of Parliament?
No.
Have you descended on Clerk of Parliament?
No, that is not an accurate.
Read the story first. Maybe you.
I have read the story, but he's here.
Am I an MP?
But in the main story, they describe you as a member of the NDC communication team. So definitely the MP.
Read the story before.
I've read the story.
I'm sure this person didn't deny it.
MFA, first of all, it is rather unfortunate that I do not get a bite on the attempted propaganda.
You're late. Next time, come early.
My brother decided to do with utility price hikes, especially when we lived under very difficult circumstances.
You have mentioned it's unfortunate. Maybe another time when we are talking about
Yes, under very difficult conditions. And we are still living the effects of many of the bad choices that they exercised in the last 8 years. And like we continue to see, 11 months would not be sufficient to undo the damage these guys caused the Republic of Ghana in the last 8 years. And many of the effects can be seen in the power sector and petroleum for that matter. So he knows. If Ghanaians have every legitimate right to be concerned about hikes in utility tariffs. And unlike them,
when we have time, I promise we'll go back to it.
We would do whatever is necessary to ensure that we lessen that burden as we begin to get a handle on the economy and the effects of their bad policies in the last 8 years. Having said that too, on the Kpandai matter, listening to my brother, it is quite clear that he has been infected by the Annor Dompreh disease.
What's that?
Erratic behavior that is not grounded in any form of rule or law, as far as the Kpandai matter is concerned. And that was what we saw 2 days ago in Parliament. You see, this is a country of laws. And whatever is done must be done in tandem with the law. And if you are a responsible citizen of the Republic of Ghana, and you believe that there's a discretion being exercised contrary to the rules of engagement or the laws of the Republic of Ghana, the most responsible thing to do is to invoke the same rules or laws to ensure that you protect your rights, not to be reckless. And out of your recklessness, undermining the very constitution you seek to demand your rights from. You don't do that. That is irresponsibility. And that point needs to be made. MFR, why do I say so? Look, the High Court is mandated under our laws, unlike the presidential petitions, to deal with issues of parliamentary disputes at the constituency level. That is the core mandate when it comes to elections of the High Court. A High Court judge has decided in accordance with the law that Kpandai needs to be rerun. Indeed, these were declaratory orders given by the High Court. The MP in question, some leading members of the NDC in Parliament, the front bench, immediately after the decision of the High Court, invited Speaker of Parliament to declare the Kpandai seat vacant. What did the Speaker say? The Speaker, they are chastising today, and the NDC. The Speaker took protection under CI 19, Rule 27, and says that in orders of this nature, there is an automatic 7-day stay, and resisted the invitation by the NDC majority to declare the seat vacant. That was the most responsible thing to do. He did that. And at the time he did that, you people did not chastise him as being NDC.
What does the law say that the Speaker should do after 7 days? Wait.
The law doesn't require the Speaker to actually even do anything. And that's why I was interested in his declaration of his references to Article 112. MFA, read Article 112. That power of decision and declaration is vested in the Clerk of Parliament. Read it. The Speaker has no role to play in that particular Article 1125 he made reference to. Check Article 1125. And tell me where it is said that the Speaker, after a High Court has declared vacancy, the Speaker also has to proceed and declare vacancy. Tell me where. In Article 1125. And mind you, the clerk is performing a constitutional duty. This is not statutory. This is not, what's the name? An act of parliament. This is the 1992 Constitution of Ghana we are talking about. That places a responsibility on the clerk of parliament that anytime he gets such a communication, either from the speaker or a court, that a seat has become vacant, he ought to oblige and write to inform the Electoral Commission of that vacancy. He receives a court order and he proceeds after 7 days on the basis of that court order to declare or to officially inform the Electoral Commission that a vacancy has occurred. So if you are a responsible political party, what do you do? And you know you have filed a stay of execution in relation to that particular judgment. MFA, what do you do? First of all...
It's actually the question everybody is asking.
Exactly. There are internal rules. Your own parliamentary rules affords you the opportunity to responsibly bring out the matter in the form of a motion to engage the conscience of the speaker. Not demonstrations, not noise, not disruption.
What are you saying at all?
Only for the speaker to walk in.
Oh, no.
You have forgotten all the internal laid down rules of parliament and you jumped into the fray, threatening to disrupt government business, not NDC business. And these are some of the key things we must take interest in. Annor Dompreh, on behalf of the MPP, threatened the entirety of this nation. Because he said they were willing to disrupt government business. A serious crime.
He said they were not going to be part of it.
No, he was emphatic. He said they were willing to disrupt government business. Disrupt the government, the business of the Republic of Ghana. You think that MPP's interest is much bigger than the interest of the Republic of Ghana? Because we are not talking about an NDC interest. For a member of parliament to have the effrontery to dare the entirety of this country that he would disrupt government business is something we must all condemn. That is criminal in nature.
So if I understand, if all of this is happening in Parliament...
He's not speaking to the issue.
Sorry?
You realize he's not speaking to the issue.
If all of this is happening
he has decided to dance around it.
What then should be happening to
what issue? I'm speaking to the issue.
That allows the person to seek redress?
I am going to the stay of execution.
Okay.
Make no mistake. That is why CI 19 gives automatic stay of 7 days. It is clear that when it comes to certain forms of declaratory orders by a court, stay of execution cannot be attained.
Well, when it said certain forms, did it describe the form and shape these forms should take?
Yes. Many are of the view that the High Court declaration was not an enforcement or a directive to conduct elections. It was a declaration to the effect that the electoral rules were not followed, and so the elections were null and void. And so in that form of being declaratory, you actually cannot secure a stay of execution. It doesn't apply to it. That's one.
Wow. This is a school of thought of it.
That is a school of thought.
Okay.
Another school of thought says that if you look at the entirety of the declaratory orders, and it is such that it mandates another institution to do something, then you may be entitled to a stay of execution. And so those who agree with that school of thought are of the view that to the extent that the consequential effect of the nullity would be to the effect that the Electoral Commission ought to organize another election, that it is mandatory in nature and a stay could be possible.
When the High Court declares with the number of days, which is 30 days, does that not make it quite emphatic?
If it declares, well,
it says 30 days.
So that's the point. So then it comes under the mandatory school of thought, who are of the view that under such circumstances, you could secure a stay. But then, another interesting point that we need to appreciate is the fact that MFR, in the light of all that, your ability to subsequently get a stay empowers you to render otiose the letter written by Clerk of Parliament to Electoral Commission. Because the clerk is under a constitutional obligation to communicate to the Clerk of to Electoral Commission, which he has done. If you subsequently get a stay of execution, it makes that letter irrelevant.
If you subsequently get the stay of execution after the declaration.
After the declaration of what?
The 7 days.
Yes.
After the clerk has written or notified the EC that the seat is vacant.
In fact, after the stay, if he gets the stay of execution, the Electoral Commission will be prevented by that stay from actually proceeding to declare a date for the election.
What then happens to the...
And if they had already declared a date for the election, then it becomes difficult for them to go by that date, because by then there would have been a direct stay order.
No.
What is not true?
You land.
What is not true? No, what is not true?
What you are saying, but
if today the Electoral Commission...
problematic.
No, you don't understand it. So
don't worry.
The Electoral Commission yesterday, didn't they set a date for the election? 30th. So if tomorrow we have a stay from the court, will the Electoral Commission proceed with the 30th date? MFA, will they be able to... Will they violate the court order and proceed to organize elections on the 30th?
By this time, what will the declaration of the vacant seat, what would then happen to that declaration?
It means that it is stayed. It does not mean that the declaration is rendered void. It only means that the implementation of that declaration is put on hold.
Or the implication of that direction?
No, the implementation of the decision, the earlier decision, because the directive is that, look, there's a nullity. So if there's a stay on the High Court's decision, it simply means that don't implement the order yet. Wait until a final determination of the matter. That is what a stay means. Perfect. MFI, are you following? That is what a stay means. So if they say stay the implementation, the Electoral Commission would have no option than to oblige and respond by staying.
But by this time, where it will have an impact in the implementation of that action of the vacant seats being declared in Parliament, what then happens to that particular seat, the Member of Parliament and all? What then happens? Because
there is a stay. That is why I told you that the letter then becomes ineffective. The letter coming from the Clerk of Parliament to the Electoral Commission.
Agreed.
Because to the extent that the stay, that means the status quo would be forced to remain.
I want to take you back. Because something must have triggered that declaration of the vacant seat. So if that stay of execution, which would have then implemented the effect of that declaration, is stayed, we'll take 2 steps back. What then happens? The Member of Parliament...
taking 2 steps back. They're just telling you that things should stay as they are.
Okay, and then the seats will be declared vacant.
The vacant MP be given an opportunity to sit. And in that case...
To sit?
Yes. Yeah, he can go back to Parliament. This is
what I want to know.
He can.
Yeah.
He can. He can. That is why. Oh, if you were, that is why he can.
Okay.
If there is a stay, and that's why I'm telling you that the letter of the clerk becomes irrelevant, because it is the letter that has declared the vacancy.
Okay.
It's and really communicated.
I need a clarity, because the letter can be irrelevant. Does not mean that that seat is still not vacant.
Oh no, it will be if the letter, because the basis of now, the basis of the declaration of the vacancy now is that letter.
Okay.
And if the letter, please, can I finish my submission?
You finish.
Please.
So,
we are done with the submission. We are getting to solutions.
Why? Yeah. I'm receiving text messages that suggest that they want to learn.
Yes.
They want to just follow.
So let me land on this issue. My point has always been quite straightforward. I indicated that to the extent that there was a stay in execution, an application for stay of execution of that particular judgment, the clerk of parliament would have exercised two options. Either to protect himself with the stay application or proceed to honor the constitutional obligation under Article 1125. He has elected to do the latter.
The latter.
By doing so, if he had done so, if he had refrained from doing so and proceeded that, look, this is the course I want to go, I'm sure that he would have still been protected. And I think that is the misinterpretation they got from my analysis. I do not have any problem. In any case, they were supposed to sit on the stay application yesterday, the same High Court. I am not aware as to whether indeed they did or not.
Yeah, then they did, but then the outcome will be made known on 18th.
On 18th. So I am not aware as to whether they did or not.
Okay.
But from where I sit, it is practically impossible in accordance with the law for any application of a stay to succeed in this matter. Yeah. And you can quote me anywhere. Yes.
What did you say, sir?
And mind you, before the clerk takes such a decision, Parliament has its own legal team.
Okay.
They would have engaged. The possibility of a stay, I do not see that happen. I do not.
I mean, they say that good lawyers are those who are able to find the law. Right?
I do not.
If you find a good lawyer and it happens, it means that the
basis of your stay is going to be that you have filed an appeal. And so therefore.
I mean, it's not strange.
The standard for stay of execution is higher than just the mere filing of an appeal.
Why are you worried for them? Maybe they are very certain.
And you see, MFA, let me land. These are the people, under a minute, these are people who on one breath are chastising our judicial system.
Absolutely.
And saying that is the reason why they are not willing to go to court to enforce their rights, because if they go, they will lose. So they opted to demonstrate in Parliament. On another breath, that same group of people are those inviting us to respect a mere application for a stay of execution of a court, and that we are undermining the courts.
Well, I mean, how is that your worry?
What kind of contradiction?
We want to stay in the learning that way.
When the law favors them.
Kamal, Solomon, I'm going to come to you shortly. But Kamal, do you understand the legal argument? And my question as well is, what's the concern? There are two ways by which the clerk would have operated. He chose the former, the one that Hamza is just drawing our attention to. If before December 30, your processes, you're able to secure a stay and even still go to want to quash the decision of the High Court at the Court of Appeal, it means that the election will not happen. Either ways, I don't see how it is affected.
MFA, when I started this conversation, I said we are a nation of rule of law. And I said we have actually adopted for ourselves laws in this country, and more especially the mother law of this country, which is the Constitution of Ghana. You see, and the Constitution prescribes functions to any of the organs of government. And in this case, we are dealing with Parliament, the legislature. Whether or not Article 112, followed by the Clerk of Parliament, is premature or is not premature, is the matter here. The crux of the matter is that what the Clerk of Parliament did has to do with jumping the gun when there's a judicial process in course.
But he did that after the 7 days.
No, listen. When a judgment is passed, he's, like I said, he's a lawyer. I mean, I respect him so much. When a judgment is given, there's a mandatory 7 days, which he has talked about, the CI-19 he spoke about, which the speaker actually relied on. That mandatory 7 days is given does not mean that that is the finality of the matter. Now, the point is, a vacant seat has occurred. But is it actual vacant as a constitutional fact for the Clerk of Parliament to actually write to the EC? That's where the issue is. It is not a constitutional fact yet.
I see where you're
going. Why am I saying it's not a constitutional fact?
I see where
there is an appellate process ongoing. And in every litigation where it's not final, in parliamentary, for instance, you start with the High Court and you end at the Court of Appeal. Okay? When Court of Appeal now finalizes that that matter or that election, it was invalid and that there was a nullity, what you then now have to do as a Clerk of Parliament is to rely on the judgment then Okay? But not to put the cart before the horse. That is our danger. We are saying,
we are saying,
in the beginning, I was with you.
We are saying that once there's an appeal on the decision of the High Court, and there's an appellate process that has been triggered, of course, that constitutional fact that an actual vacancy has occurred in Parliament, which warrants for you, the clerk, to write to EC, is not.
Okay,
proper.
It's
not. I am. It is what it is. And again, that's exactly what it is. That's exactly what it is.
I'm sure you can.
Okay.
I'm saying that
I'm coming to you.
I started the career.
I come with you. Solomon, the question is, here's what we're going to do. The question will be whether or not the declaration by the High Court on the seat of Kpandai being vacant can empower the clerk.
The High Court has not declared any seat vacant.
Actually, that's true.
Because
it has not.
That power. They have said that there has to be a rerun.
But it has to.
That power is vested in the clerk. The clerk of Parliament. And Article 1125.
That's interesting because then a rerun, why would we rerun? Because
that's the outcome of the court case. But that mandate is not given. The mandate to declare a seat vacant is not given to the High Court judge. It's given to the clerk.
So, with my little learning here, if you look at that declaration by the High Court, it could be direct or emphatic this morning. Does that, if I want to go by what you're saying, does this mean that the clerk, after 7 days, can decide to say that I'm not declaring that seat vacant?
I mean, that's the scenario that Hamza was trying to paint you, that once there was an application for a stay, by which I also have a different opinion, that
before the application for stay, assuming the NPP does not even go.
There are two applications. There's appeal and there's an assay for execution. Stay of execution.
No, you let me come in.
There are two things.
You see.
Well,
Solomon,
you go ahead.
I have a different view as to whether or not notice of injunction or the mere fact that someone has applied for an injunction or stay constitutes a stay.
How about whether or not the directive from the court can amount to a declaration of the seats being vacant by the clerk?
So the court has given directions. The pronouncement as to whether or not a seat is vacant is the preserve of the clerk, and which the clerk has done.
So this is he says that the answer we must find is to whether when the High Court declares that, let it be a rerun.
And there's an appeal.
And there's an appeal.
Pending.
Can it amount to the clerk declaring the seats?
Thank you. That's what the issue is.
That's the issue.
The clerk has every right. Look, in the case of Haruna Idrisu, you see, in this country, it's always good that we have precedents. In the case involving Haruna Idrisu, Mahama Yariga, and Okujeto versus the Attorney General concerning the E-levy. You remember that case? When they sought to block the president from assenting to the E-levy because they had an issue in court, what did the president of the day say? He signed it. Because to him, notice the mere fact that you are going to court seeking an injunction did not amount to injunction. The mere, are you getting what I'm saying?
I'm with you.
So the mere fact that Nyindam and his people have gone to court seeking a stay does not amount to a stay being granted. Because as we speak, the only decision from the court is what we have with the High Court. And what does the High Court decision say? Say
rerun.
Absolutely.
Can that, since it is not a declaration that a seat is vacant by the High Court?
Yes.
And my learning is that it is the clerk from you this morning. It is the clerk that has the power to declare that seat vacant.
Yes.
Can the directive from the High Court amount to that seat being declared vacant?
Absolutely. I'll give you the indication, but they do not have the power to say that it is vacant.
So they say, I know it, but I won't say it. You say
absolutely. They know their level. Okay. Their level is to deal with the matter. They have dealt with the matter. It is for the clerk to declare the seat vacant, which the clerk has done.
So but does the clerk have the power to say, I won't declare it? And then the Kpandai...
No, he has no power. He has no power. But of course he has no power. It's an order from the court.
And then it's an order, then?
Yes.
It's not in order.
That what?
then you're telling me now that the clerk has no choice.
Absolutely.
That's very emphatic.
Absolutely.
Okay, but Hamza, do you see the direction? Do you see what he says? Because it's the same constitution that empowers the clerk.
Yeah.
And it's the same constitution that allows a person to go through all of the judicial processes to get finality.
So the
do you understand
question is that Article 19, has that been exhausted?
But the mere fact that someone has also applied for a stay does not mean the person will be granted. Let's take this scenario.
It is not bad.
Let me just...
I don't know why we are doing this.
So that, let's take this scenario. If Nyindam, between the state
and
Nyindam, if Nyindam, the mere fact that application for a stay has been filed, and you allow Nyindam to stay or be in parliament and continue to draw salaries from the state, in the event that the stay is not granted, how do we get that money from Nyindam? Between the state and Nyindam, who will have the capacity to reimburse the other? That's what you have to take into consideration. And that is why I believe that what the clerk has done is in order.
Okay. Hamza, but do you see why I'm coming with Kamal's issue that he's just raised?
Is that simple? Isaac, 4 years. It took 4 years. Just at the tail end of Parliament being dissolved.
I promise you that I think the issue is quite clear. Let me get you. Let me get from you. Kamal, I promise the issue is very clear.
First of all, there's a final judgment of the court. The fact that you have filed an appeal does not mean that it invalidates a final order from the High Court. That is not the position of the law. That is politics. Until such a time that an order comes from the Court of Appeal directing otherwise, as far as the High Court decision is concerned, there's a final conclusive judgment on the matter that is standing as far as the law is concerned.
So what
and that is the decision of the
educators. What happened to appellate process? With all respect, if I go to a court of first trial,
no, but
a trial court,
I'm
just asking a simple question. No,
you
help us. You are a lawyer here.
Kamal,
but if you are patient for me to learn,
but in my simple,
it's a simple question.
It suggests that if the Court of Appeal questions the decisions of a lower court, their decision doesn't.
I'm asking a simple question. Why do we have appellate process? We go to court A, and the court says, "This is my decision." The court now, the judicial process now gives you a window to appeal against it. And I'm asking simple question.
But the CJ has
said that it's final, and there's an appellate process that has been triggered. When the appellate process is not decided on, does it still mean that that decision holds?
But neither your stay of execution also has been granted,
exactly. So in the wisdom of the law,
there are two things.
In the wisdom of the law, they know that when a lower court gives a decision, it is binding. Until you take steps through an appellate process to set that aside.
Excellent. It is still binding.
It is still binding.
Yeah.
Excellent.
If you are in court in the form of an appeal, the decision is still binding until such a time that the appellate court determines it. So they have given you tools to ensure that you protect your rights in the interim whilst the appellate decision process goes through. What are the tools? Injunction or stay of execution. But the courts themselves have told you that it does not mean that when you bring these tools before them, it will be granted.
Okay.
And so if you file a stay of execution and the High Court judge rejects your stay of execution, you wouldn't say that the vacancy is invalid because you are appealing, you are the Court of Appeal.
I can't help but come along with this logic.
Are you following the point?
Yeah, that is a law. Help but come along with
that is a law. And you see, my brother raises another interesting issue. And he makes the point that when it comes to an appellate process, like the application for an injunction or a stay, does not necessarily mean that it is stay. It is true. That is according to, as recent as the Vincent Asafua matter. I think that the Supreme Court settled the matter and said that when it comes to constitutional bodies, the mere application for a stay of execution or an injunction does not constitute a grant of same, and for which reason one is expected to oblige, especially when it comes to constitutional bodies. And I'll just read it. This is Kulendi saying, JSC, in good conscience and in fidelity to our judicial oath, we cannot endorse a position that could potentially be exploited by deliberate and well-resourced strategy deployed by individuals or entities pursuing parochial private interests to obstruct, delay, and frustrate constitutional oversight and hold the public interest to ransom. End of quote.
You have a higher authority.
And you see, Anna, but I need to draw a distinction where the confusion is.
Okay.
So this case is conclusive, it's tentative in a way. But even within the legal fraternity, when it comes to stay of executions under CI 19, It is statutory in nature. That one is specific. For example, the 7-day stay, automatic day stay. Then there's also under Article 2, Rule 27(2) or so, that says that the mere application of a stay would operate as a stay until the matter is heard. That is, the application stay is heard. It's also there. Are you getting the distinction, Solo? So now, there's that contention, whether this decision effectively overrides a statutory provision. A statutory provision that has been created and provided for in law. This decision relates to precedents of the same Supreme Court. So we need that.
No,
so you get it. We are on the same page.
It's a policy court.
So you see,
it's a policy court.
I have a question for all of you. I have a question for all of you. I have, but I have a question for you so that we'll go to the OSP.
I am trying as much as possible.
Kamal, are you people afraid of the Kpandai by rerun or something?
MFA, let me just dispel this information that he seeks. We are not on the same page.
We are.
If there's anything, so I'm trying as much as possible to present the law as it is.
Okay.
And I'm challenging you people.
What do you
go through the legal process.
Let's go on the final round of the Kpandai. Let's go to OSP.
Anyway.
It means a lot to me because of the matter in court. My final question really is, what do you reckon is the reasoning behind the 7 days?
In
before you can
so
declare.
that if you want, if
is it for such issues of stay of execution?
Exactly.
You see,
exactly.
We first of all, on this matter, the MPP is on record to have filed an application in the Supreme Court as well. Okay.
What are you
for
seeking?
Is it the
MPP or the
candidate? The MPP. Please. You see, we are in the Supreme Court for the Supreme Court to quash the decision of the High Court in the first place. Why? We are making the argument of jurisdiction. What is a jurisdiction? The question you just asked, what is the essence of the 7 days? Time is of essence in law, which my brother knows. We were arguing at the Supreme Court that the time the gazetting of those results took place, and the time that the case, which is supposed to have been heard by the High Court,
debate can only be had
with all respect.
Yeah.
I'm only trying to explain to you why we have series of applications. First, we have one in the Supreme Court, which is.
Do you know why I'm unable to go into the why?
The number of days that you are allowed to have filed, that number of days elapsed, which didn't pass.
Do you know why I'm unable to go to the whys? Come out. Do you know why I'm unable to go to the whys?
And two,
the whys present me to revisit the facts of the matter. What I'm interested in is in the decisions of the court after they have considered all of these.
You asked the question whether the 7 days was actually significant.
Okay, and that's what you, okay.
And I'm only telling you that in law, timing is of essence. That's why I said that we are going back. We are going back to the Supreme Court, even saying that the time that the case was even filed was wrong on the face of it. We have it. Then again, we have again filed at the Court of Appeal, trying to appeal against the decision of the court. So I'm saying, if all these legal processes are there, okay, and my brother sits here and tells me and cites their own laws, we say that there's a statute in place which says that, look, if judicial process is in place, obviously, whatever decision you ought to take based on a particular decision stays.
Kamal, you know what? Because at some point, there must be a time frame at some point. Yes. Because judicial process is going to Court of Appeal, even to get the Supreme Court to want to take a decision that becomes a finality on a matter. There must be, if there's an existing 7 days, it means that we're arguing. It could be 14, could be 21, could be 30, could be 1 year.
No, it doesn't work like that.
It doesn't work like that. Anyway,
no, it works
I'm just putting
once they are given time, you have to work within the time. Even appeal, you are given time to work within that appeal to be able to file your appeal. Application.
Okay.
So I'm saying all these things I don't want to anyway, but nonetheless, like we leave it.
Analysis.
Let's go to the OSP.
briefly. We also remember what Judicial Question had to go through. And the motion that was moved by the current minority leader in the case of Judicial Question that was intended and actually succeeded in preventing him from taking a decision as to who became Speaker of Parliament. It was an application before a court. That is the precedent you set. And so when we come and the same civil servants, or in this case, the clerk, based on the precedents, are invoking the laws of the country.
Is it no?
to discharge their constitutional obligations, and you have a problem with it. I have given you basis where the confusion could be. And I've made it point that, Kamal, the antidote is not noise and recklessness and a threat to disrupt government.
The first time people are making noise in parliament.
The antidote is to conduct the legal processes and challenge the decision of the clerk. But why are you afraid to challenge the decision of the clerk?
Party that has bastardized the judiciary, they have bastardized the judiciary.
Were all over on the floor.
Oh, they have destroyed the judiciary.
That one is, that one we should.
And their leader has insulted the current chief.
We're all over in parliament, saluting and dancing.
That was wrong.
Is that what they were supposed to do?
That was wrong.
Oh, that one was right.
Wrong.
Really?
No, someone.